The Supreme Court has another petition for certiorari raising questions under the safe harbor in Section 546E of the Bankruptcy Code. You will recall that the Supreme Court in 2018 handed down a very important decision on the safe harbor known as merit management. In that decision, the Supreme Court overruled the majority of circuits and held that the safe harbor protects financial institutions, but it does not protect transactions. In other words, the Supreme Court said rather explicitly, simply putting a bank into a chain of payments in a fraudulent transfer is not sufficient to invoke the safe harbor and make the defendant immune from coughing up the proceeds of a fraudulent transfer. About a year after merit management, the Second Circuit decided an important case in the Tribune newspaper, Chapter 11 reorganization. The Second Circuit, to the thinking of many folks, including me, was looking for and found what it thought was a loophole in merit management and went right ahead and invoked the safe harbor, letting people off of the hook for the receipt of what very well may have been very large amounts of fraudulent transfers. The people who lost in Tribune filed a petition for certiorari, and on Monday early this month in October, the Supreme Court asked for the views of the Solicitor General. That means that sometime in the winter or early spring, the Solicitor General will give his or her views about whether or not certiorari should be granted, and the Solicitor General could also give the opinion of the government about what the result ought to be. Well, importantly, this week, Bankruptcy Judge Oxholm in Detroit handed down a really important, thoroughly analyzed decision dealing with the safe harbor. And in it, she explicitly disagreed with the Second Circuit with respect to features of the Second Circuit opinion. Well, of course, fraudulent transfer and the safe harbor are part and parcel of bankruptcy practice, and there are few, I think, who will be involved in bankruptcy who will not confront these questions one time or another. I have written about Judge Oxholm's decision in my column being published today on the ABI website, and that story also talks about and analyzes both merit management and the Tribune decisions. I very much recommend that folks out there who practice bankruptcy law regularly ought to read this decision, or I should say this story. It has links to the important decisions and some analysis of the issues. I am Bill Rochelle, Editor-at-Large for American Bankruptcy Institute. I will return same time next week with something interesting that has occurred in the world of bankruptcy. Until then, be well.